A subpoena duces tecum is a court summons ordering the recipient to appear before the court and produce documents or other tangible evidence for use at a hearing or trial. The summons is known by various names in different jurisdictions. The term subpoena duces tecum is used in the United States, as well as some other common law jurisdictions such as South Africa and Canada. It is a Latin phrase meaning, "you'll bring with you under penalty of punishment." The summons is called a subpoena for production of evidence in some U.S. states that have sought to reduce the use of non-English words and phrases in court terminology. The subpoena duces tecum is similar to the subpoena ad testificandum, which is a writ summoning a witness to testify orally. However, unlike the latter summons, the subpoena duces tecum instructs the witness to bring in hand books, papers, or evidence for the court. In most jurisdictions, a subpoena usually has to be served personally, order pursuant to a deposition. In the United States, a notice to a party deponent may be accompanied by a request for production of documents and other tangible things during the taking of a deposition. The notice to produce is served prior to the deposition. This follows the federal rules of civil procedure. The method of using a subpoena duces tecum is generally valid only to compel a witness to produce documents and other things at the time of the deposition. If a deponent is a non-party to the action, production of documents can be compelled only through proper subpoena duces tecum. Depending on the nature of the documents and the volume, some may be obtained directly and before deposition under FRCP 34. In cases where a large number of documents potentially relevant to the hearing, the court may order them to be produced prior to the deposition. This forms a part of legal discovery and allows parties involved time to review them prior to the deposition or other hearing. Federal cases and some states follow Federal Rule 27 of the Federal Rules of Civil Procedure concerning the production of documents in pre-trial discovery, including those pertaining to depositions. These can include the subpoena duces tecum to produce documents, or in some cases to undergo a physical or mental examination. In the Ninth Circuit, interpreting Rule 27 literally, it has been held that a party can simply produce the documents only, and in certain cases, avoid an oral deposition when presented with subpoena duces tecum. Failure to produce documents. A continuance of a civil action may be granted due to the absence of documents or papers. The party failing to produce the documents requested by a subpoena duces tecum must show good reason why there was a failure to do so. Acceptable explanations have included loss or destruction of papers, or an agreement to use copies. The party seeking the continuance must show that the absence of the documents is not because of the negligence of their own, or of the attorney of record. Similarly, a continuance may be granted in a criminal case if there is good reason documents pertinent to the case could not be produced at the time of trial. For example, a continuance should be granted for failure to produce a transcript of testimony given at a previous trial. In general, it is reversible error to proceed with a criminal trial in the absence of a previous trial transcript, when such contains pertinent information that should have been considered in the new trial. In these cases, a continuance is the usual remedy. The trial judge or magistrate is the one who issues the continuance. A party's failure to produce subpoenaed evidence, where the evidence is under the control, may support a request to a finder of fact to create an adverse inference that the evidence would have been unfavorable to them. Jenks Act cases. In the 1957 case Jenks v. United States, the United States Supreme Court ruled that a defendant must have access to government witnesses who will testify against him in a criminal trial, and must also have access to any documents pertaining to the testimony. This includes papers, documents, written statements and the like. This led to passage of the Jenks Act, 18 U.S.C. Part 2, Chapter 223, Section 3500, which allows for subpoena duces to come of relevant government documents, but only after a government agent or employee has testified at trial. There can be no pre-trial discovery. The subpoena is allowed by the trial judge. The government has the right to deny access to the documents. This may be due to the sensitive nature of the documents or because they are classified. In such an instance, the accused is permitted to pray unto the court for remedy or sanction against his accuser or plaintiff, for his inability to be able to confront the papers and/or facts that assert to support the accusation against him. The court, in law and equity, is required to answer such a prayer. If the accused's prayer is not answered in a manner that favorably restores the balance between the accused and the government in criminal cases, or between the defendant and the plaintiff in civil cases, it is grounds for an appeal if a mistrial is not granted. The United States Supreme Court dealt with this issue in federal civil cases in United States v. Reynolds. If the remedy is granted, there is a mistrial and dismissal of criminal charges. An accused criminal has no right to subpoena the work product of the prosecution in a criminal case. Writ of Mandamus. The writ of Mandamus is appropriate to compel surrender of documents in the possession of attorneys or other persons that have been illegally obtained under the abuse of a writ of attachment. Mandamus can vacate an order to produce books and papers. However, mandamus is not the proper remedy to quash a motion to compel a district attorney to relinquish books and records to his successor officeholder. In an 1893 case, the United States Attorney in Alabama refused to vacate his office, refusing to surrender books, papers and other materials in the possession of that office to the newly appointed U.S. Attorney. The federal court in Alabama issued a writ directing the previous attorney to relinquish the documents. He, in turn, sought relief from the Supreme Court, which denied his application, saying it would not interfere with the properly conducted internal matters of a court. In the case in re. Parson, the United States Supreme Court wrote, "If the orders be regarded merely as directions in the administration of judicial affairs in respect of the immediate possession of property or custody of prisoners, we cannot be properly called to, by reason of anything appearing on these records, in the exercise of appellate jurisdiction in this manner, to direct them to be set aside, and if the proceedings should be treated as involving a final determination as on issues joined to the right to such possession and custody, there was no complaint of want of notice or of hearing, and the summary made adopted did not in itself affect the jurisdiction of the circuit court upon the ground that it had exceeded its powers." Mandamus is the remedy where a lower court has clearly failed to issue compulsion to produce documents, or to allow the petitioner access to such documents as may be in the possession of the court of the parties to the action. Mandamus can be used to compel a court to enforce an order to answer interrogatories. Mandamus is the proper remedy to compel the quashal of a subpoena duces to come for the production before her jury of attorney-client privilege. Presumably, this would apply to attorney work product, although there is no case law on the matter. Commitment of witness. Contempt of court. A witness who has refused to obey a lawful order to produce books, documents and papers may be properly incarcerated for contempt of court. A writ of habeas corpus will not apply, unless it can be shown the witness could not have legally had possession of such documents. In such a situation, the writ of habeas corpus will properly apply, and is the remedy for such improper action. At common law, law, and under various statutes pertaining to a given jurisdiction, a right to action for damages, or for a statutory penalty of forfeiture, exists against a witness who, without sufficient excuse, fails or refuses to give oral testimony or to produce documents or other specified items in obedience to the command of a properly issued and served subpoena. There are certain conditions precedent or defenses to a recovery of damages for a person's failure to testify or to provide documents pertinent to a hearing or trial. There must be a breach of testimonial duty after having been properly served with a legitimately executed subpoena. There must be a demonstration of actual damages incurred from the absence of testimony. Most courts have rejected the arguments for seeking damages in this kind of case. Giving false testimony in a judicial proceeding, even though the allegation is made that the person giving the testimony knew it to be false, does not give rise, either at common law or by statute, to a civil action for damages resulting from such testimony. The situation is probably different if intentionally false documents are submitted under a subpoena. Duces tecum. Privileges. Attorney-client privilege is generally recognized by the courts. Communications between lawyer and client are generally immune from subpoena. In other words, the lawyer cannot be compelled to testify in a trial unless the lawyer becomes, or appears to become, a party to the litigation. A similar situation exists with work product, meaning written documents or computer records generated in preparation for a trial or hearing. This includes information such as potential questions that may be asked of witnesses, lists of possible witnesses, memoranda, notes, trial strategies, written briefs, or documents that may or may not end up being used in the course of litigation. Usually, none of this can be the subject of a subpoena. Duces tecum. If a communication between lawyer and client is made in the presence of the third party, the privilege is not recognized to exist. The federal courts will apply the common law rule of attorney-client privilege unless there is an intervening state law applying to the central issues of the matter. In those cases, the federal court uses the effective state law. Physician-patient privilege is usually statutorily defined and can vary from state to state. The usual rule is that medical records are immune from subpoena if the plaintiff has not alleged physical or mental injuries or damages. Once the plaintiff alleges physical or mental injuries proximately flowing from a potentially tortious act by the defendant, or in some other disability hearing, medical records can be subject to subpoena. Duces tecum. While witnesses may try to resist legal discovery by asking the judge to protect them from questioning or inspection of documents, the policy of the courts is in favor of full disclosure. It is the intent of the rules of procedure that pre-trial discovery take place without any intervention of a judge. So-called fishing expeditions are permissible under Federal Rule of Civil Procedure 26. This rule is repeated in many states as rules of procedure. Parties may obtain discovery regarding any matter not privileged which is relevant, if the information sought appears reasonably calculated to lead to the discovery of admissible evidence. The looseness of the definition of relevant evidence is generally construed to mean liberal production. The physician who is the party to an action does not own the records of patients he has treated. They are not privileged if the patient has waived confidentiality. Physicians must produce medical records under subpoena. Duces tecum. Peer review records and other hospital documents of quality control committee meetings are generally not subject to subpoena. Duces tecum, since these have statutory immunity. The theory is that the frankness of peer review would be chilled if these records could be routinely compelled. Several United States federal circuit courts have recognized a limited reporter's privilege. The United States Justice Department has a self-imposed limitation upon subpoena of reporters and the notes documents. This privilege is not universal, and is incomplete. Internal memos from scientific and medical journals generated in peer-reviewing articles for publication are generally immune from subpoena. In some states, rape crisis counselors and domestic violence advocates hold a statutory privilege analogous to therapist-client privilege. However, these privileges are not absolute, and may be overruled by a judge upon a showing that the probative value of the information outweighs the effect of disclosure of the information on the victim, the counseling relationship, and the counseling services, or under a number of other limited circumstances. To respect and preserve the privacy of sensitive material contained in such reports, the judge may require the disclosure of confidential information to take place in camera, so-called priest-penitent privilege, which precludes forced testimony of confessions made to a priest, minister, or religious advisor as statutorily defined in the United States. They vary between states. In some cases, the privilege is confusing and ill-defined. In others, there is recognized stare decisis, spousal privilege, executive privilege, reporter's privilege. Pre- and post-judgment execution proceedings. Discovery can be authorized for the production of documents for both pre-trial and post-trial actions. Most states either follow, or have modeled the procedures after, the Federal Rules of Civil Procedure Rule 69. Judgment creditors are permitted to ask questions about a debtor's residence, recent employment history, business relationships, including partners, co-shareholders, co-officers, co-directors, the contents of a will, transfers of property, and the identity of persons who either owed a debt to the judgment debtor, or received things of value from the debtor. Information in bank accounts can also be the subject of a subpoena duces tecum. In federal court proceedings concerning judgment debtors, the inquiry is usually limited to the discovery of assets. In international cases being tried in United States federal courts, the application of the Hague Service Convention is utilized where appropriate. Public access to documents filed with the court. The right of the public to access judicial records is fundamental to a democratic state and is analogous to the First Amendment right of freedom of speech and of the press and the Sixth Amendment right to public trials. While the right to access trial records is not absolute, it is framed in presumption of public access to the proceedings and records. United States Code 11, Section 107 of the Federal Bankruptcy Law, is a codification of the common law general right to inspect judicial records and documents. However, the right is not absolute and may be denied when the entity seeking to view the records has an improper purpose. The general intent of the statute is to favor public access to court documents. Production of documents in bankruptcy. An entity may be compelled to produce documentary evidence in accordance with the subpoena powers of Federal Rule of Civil Procedure 45 as applied by Bankruptcy Rule 9016. The United States Bankruptcy Court has powers to compel production of documents from a non-debtor corporation or person, concerning transactions involving the debtor corporation or person. Production of documents can be challenged as being burdensome. Assets diverted to outside corporations have bank accounts, stock portfolios and such other assets as land holdings lie within the power to compel production under subpoena duces tecum. Federal law recognizes no accountant-client privilege. A subpoena duces tecum served pursuant to Bankruptcy Rule 2004 is not a violation of accountant-client privilege. 11 United States Code Section 107 provides that papers filed in cases under the Bankruptcy Code and dockets of the bankruptcy courts are public records and are to be open to examination at reasonable times without charge. compelling a foreign corporation to produce documents. A domestic corporation may be considered to be a person within the meaning of the 14th Amendment of the United States Constitution. It is not necessarily to treat a corporation as a person in all circumstances. United States case law is confusing concerning this matter when dealing with foreign corporations and their operation within the United States. Especially troubling have been rulings concerning the 4th Amendment of the United States Constitution and 5th Amendment to the United States Constitution. A foreign agent may not claim 5th Amendment provisions against self-incrimination, nor can records be withheld from subpoena duces to come on the grounds that production of such documents would incriminate officers or other members of the foreign corporation. However, there is case authority in which foreign corporations have been protected from illegal searches and seizures, including documents and books. The matter of a foreign corporation operating as a person within the United States being afforded protection under the 14th Amendment is discussed. Subpoena of welfare documents. Statutes governing the disclosure of information contained in welfare records exist in many jurisdictions. The rationale for the existence of these regulations is to encourage full and frank disclosure by the welfare recipient of his situation and the protection of the recipient from the embarrassment likely to result from the disclosure of information contained in such records. In some states, records can be disclosed at the discretion of the State Director of Welfare. In general, welfare records are not public records, and should not be considered to be such. Disclosure of information is usually limited to purposes directly connected with the administration of welfare benefits. The investigation of costs of welfare programs have been held to be sufficiently related to the matters in question to justify disclosure. Statutes designed to limit welfare record availability are generally held by the courts to be not immune from the power of subpoena duces tecum. Certain state laws limit the availability of information that can be obtained from the subpoena of such documents. These are always subject to a court challenge on a case-by-case basis. Welfare recipients are generally allowed access to the files by subpoena duces tecum. Death of a welfare recipient is considered in some states to be sufficient reason to remove the reason for confidentiality. Some states have passed so-called right-to-know statutes which would make welfare recipients and the information available to the public. These, along with common law, and state and federal constitutions guaranteeing freedom of the press, do not give newspapers the right to access the names of persons on welfare, or the amounts they receive. Federal Trade Commission hearings in monopoly actions. Whenever the Federal Trade Commission has reason to believe that any person has violated 15 U.S.C. Section 13, 14, 18 and 19, it must issue and serve on that person and on the Attorney General of the United States a complaint stating its charges in that regard. The notice shall also give a date for a hearing in the matter. Delivery of the subpoena duces tecum for production of documents may be done in person, or by certified letter. Receipt of the letter is considered proof of service. Power to issue subpoenas is extended to Robinson-Patman Act cases of price fixing and Clayton Act cases of unlawful acquisition. A federal district court lacks jurisdiction to enjoin the Federal Trade Commission from proceeding in an investigation. It cannot stay a subpoena duces tecum to produce documents in the investigative stage. An injunction by a federal court does not have the power to restrain the FTC from enforcing an order requiring corporations to furnish reports and documents on 15 U.S.C. Section 49. The only relief available to stop a demand for documents is to seek an action of compliance in mandamus by the Attorney General of the United States, or under 15 U.S.C. Section 52 enforce fines and forfeitures. If the FTC institutes an adjudicative proceeding, the person who originated the matter by complaining to the FTC is not a party to the action and does not have any control over it. The FTC may allow the complaining person to participate in the proceeding by virtue of 15 U.S.C. Section 45. This allows participation for good cause, either by counsel or in person. You cannot intervene in an FTC hearing, except by demonstrating that substantial issues of law or fact would not be properly raised and argued, and that these issues are important and immediate enough to warrant additional expenditure of FTC resources. This involvement can be enhanced by subpoena duces tecum. Pre-hearing conferences are the norm. These are useful in clarifying or simplifying issues, amending pleadings, entering stipulations, admissions of fact and contents and authenticity of documents, expediting discovery and presentation of evidence, including restriction of witnesses, matters subject to official notice that may be resolved by further production of documents related to the case. In general, pre-hearing conferences are not public. The FTC is not restricted by a rigid rule of evidence.